This episode of Tennessee Court Talk is discussing an order to show cause. How does it work, and how could an order to show cause affect your court case? Joining me today for discussion are two judges from the Tennessee Court of Criminal Appeals, Judge Ross Dyer and Judge Tom Greenholtz. Let's start with you, Judge Dyer. At the very basis of this topic, what is an order to show cause?
So, simply put, an order to show cause is this court has our court at some point in time has on multiple occasions advised an attorney to do something, file a transcript, file a brief, something like that, and they have failed to comply with an order of this court. And so we will enter another order telling them that they have to appear in front of us and show cause as to why they should not be held in contempt for failing to do what we've been asking them to do. That's probably the most simplistic way I can describe it.
Judge Greenholtz?
I think there are a lot of different types of kind of show cause orders. Some are more serious than others. If you haven't gotten a transcript filed on time, the court will put down an order asking you to show cause about why certain action shouldn't be taken or something like that. In a more serious case where maybe the prosecution of the appeal has just languished, maybe the appellant hasn't filed a brief or done something that must be done before the appeal continues. The calling of the order as a show cause order is really kind of a misnomer. It may be that sometimes a show cause order may tend to imply that the burden is necessarily on the appellant or the appellant's lawyer in that case. Might not be true, frankly, if the court is looking to actually punish someone for a willful violation of the court's orders previously. And so I think in the vernacular, we call those more serious ones show cause orders too, but they're really a little different. It's not that the appellant is showing cause for why action shouldn't be taken. It's really the court and itself saying, hey, we need a better explanation about what's going on here. It looks like you're in willful disobedience of a court order. And we're going to have a further discussion about it. But yeah.
Does a show cause order always end up in some sort of hearing, or can you reply without a hearing?
We could craft them however we choose, I guess would be the accurate answer. That being said, I think every one I've ever seen it is you're to show up on this date and show your cause as to what's happening, why we shouldn't take further measures, whatever. I don't know that I can't recall in my time that I've seen where we've put down a show cause order and we've just allowed someone to file a response and we say, okay, thanks.
There have been some times that, this is kind of interesting. I was talking about this topic with our one of our staff attorneys over here in the East. And it looks like, it looks like there is a kind of a divergence between the sections maybe sometimes about how show cause orders are addressed and dealt with. There are times in the East where a show cause order will go down on a less serious matter, perhaps, than holding someone in contempt. And in those cases, we do resolve them kind of on the papers. So there could be an example that I'm thinking of, maybe a pro se appellant has come in, and pro se appellant either may not know the appellate rules or some other things. And after rounds and rounds of notice, we'll put down a show cause order asking why the appeal shouldn't be dismissed. And if the appellant doesn't respond or gives insufficient reasons, sometimes the appeal is dismissed. And that's done without an in-person hearing. I think Judge Dyer is right, though. When you start getting into contempt issues, that's always going to be a hearing. I think the court has to be able to see the lawyer, offer the lawyer an opportunity to be heard, be represented by counsel. But in point of fact, the court really wants to know what's going on.
So an attorney receives an order to show cause. What happens in the hearing itself?
The first thing, and Judge Greenholtz just alluded to this, it's a true contempt hearing at that point. And so first thing is letting them know they have a right to have counsel, that they are under oath. So whatever they start telling us is considered to be under oath. But then really it is a fact-finding discussion. I mean, that's kind of how I would describe it. Attorney X, here are all the things that we've asked you to do and the orders we've sent and the phone calls we've made that you have not been responsive to. And we would like to hear from you as to, why you haven't done these things. I will say for me, in that discussion, one of the inquiries I always make is, does your client know you're here? Does your client understand that the three of us right now could dismiss your client's appeal because you failed to do your job? So does your client know you're here? One of the things and this is me, but that I'm always in favor of putting in whatever order we put down is you have to send a certified letter to your client telling them what has happened, what's going on, and then you file a copy of that with the court. Because that, at the end of the day, and Judge Greenholtz alluded to this when he was talking about a pro se litigant, we could dismiss your appeal. Yeah, if you fail to comply with the rules, that's one of our remedies. Is we just dismiss the appeal, and so when I am inquiring of the attorney as to what's going on, one of my main concerns is, does your client know what's going on? I want to know what's going on. Is there something we can do to help you? Do you have an issue? Are you really just willfully disregarding our orders? But also, does your client understand that, he may be sitting in prison on a 30-year sentence and we're getting ready to kick his appeal out? So that would be kind of my thoughts on kind of what goes on and kind of how they start.
Yeah. It's kind of an interesting question because as a practical matter, the person who's being summoned into the contempt hearing has due process rights, because if the attorney is found to be in willful disobedience of a court order, there's going to be a punishment. There will be a sanction, and so the attorney has the right to notice. The attorney has written notice, setting forth the facts and the allegations. The attorney has the right to know when and where to show up. The attorney has the right to counsel as it goes, and the attorney has the right to have proof put on. One of the things the court typically will do is ask the lawyer at the beginning of the hearing, do you dispute the facts? Or do you agree that the facts as laid out in the notice are accurate? Do you want to supplement those? Do you wish to have proof put on about those facts? I haven't been in a hearing yet where a lawyer has said, I completely dispute everything that is being alleged here. I demand that proof be put on. If that were the case, the court would ask the attorney general then to prosecute the action. I don't know what would happen, candidly, Ross. What would happen if the AG refused to do so? In the trial court, the district attorney is not required to prosecute a contempt, and so sometimes there could be a private lawyer appointed. But the lawyer who has shown up for the contempt hearing has that right to have a hearing. Most of the time where I've been in the hearings, the lawyer concedes at least the factual basis, and what we're really talking about at that point is what should happen from there. What's also interesting to me too is that by the time we get into a contempt hearing, I mean the issue has been going on for a while. So typically with let's say a circumstance where an appellate has failed to file a timely principal brief, 30 days comes and goes after the record is filed, the clerk will send out a notice to say, hey, you haven't filed your brief yet. Sometimes that notice comes and goes, no response. Then we send out an order that says, hey, not only did you not file your brief on time in accordance with the rules, you ignored the clerk's gentle nudge that we need to get your brief in. File your brief within however many days, 20 or 30 days. Here you go. When the appellant doesn't respond to that notice, that's when the show cause comes down that says, all right, you have blown through not only the rules, you've blown through the clerk's notice, you've blown through our order. Now we're going to have to ratchet this up a little bit. You're hereby ordered to show up in court at this time, at this day, and we're going to talk about the issues a little more seriously.
Let's just go ahead and jump into that. Judge Dyer alluded to this to begin with. Is that the only way for a client to receive notice that their attorney is being show cause? Is the attorney has to contact them? I mean, I know you said they have to show proof that they've contacted, but there's no contact by the court. There's no contact by the clerk's office, anything like that.
As I understand how the clerk's office, operates at that stage, it's, they're sending all those notices to the attorney of record. They're not sending those notices to the client. And so, yeah, I mean, the only way a client's going to know that his attorney is in court that day on a show cause hearing, or that things haven't been filed and aren't progressing, or they have been filed and everything's progressing fine, is the communication between the lawyer and the client. Well, the court does not get involved in that until you get to this point. And then that's when, we will get involved. But yeah, up until that point, the client has no clue what's going on.
I think there's a reason for that. The clerk's office does a great job. So Jim Hivner and his deputy clerks do a great job in all of the divisions. One of the things maybe that we would not want the clerk's office doing is interfering with the client-lawyer relationship. And so at least before it gets to the point where we're talking with the lawyer, it may be that the communications from the clerk's office should go to the designated counsel of record as it goes. Once it gets to us, though, and we're talking about willful disobedience of court orders, at that point, I think it's appropriate for the court then to direct the clerk's office or the counsel of record to let the client know. Of course, if the lawyer's abiding by his or her duty of communication under the rules of professional conduct, we wouldn't need that to begin with. But the court's order is a backstop to make sure that ethical duty is being complied with.
Judge Greenholtz, you sort of alluded to the steps that the clerk's office takes and that the court takes to try to get an attorney to appear for a show cause hearing. What happens if that attorney does not appear to the show cause hearing?
It's going to be bad news. It'll be bad news. Ross, I'm trying to think if I've had one where the lawyer hasn't shown. As I'm reaching back, I remember one where the lawyer was late. So the lawyer was scheduled to be at court maybe like at 9:30 when court opened, wasn't there, but at least let us know that the lawyer would be there at 1:30 or whatnot. So, being in touch with the court is helpful. I haven't seen an issue where the lawyer has just willfully failed to appear. As it goes, in the old days, the stories are apocryphal, no doubt, but in the old days, it may be that a capias was issued at that point.
Yeah. I think that's correct. I think that's correct, Tom. I mean, I've probably been on, maybe I'll even say 2, but I mean, that's very few if you think about it in the grand scheme of things. 2 where the attorney either claimed he didn't get it calendared or was late because he was coming from somewhere part of the state to where we were. But they ended up getting there, through the clerk's office to the staff attorney. Phone calls were made and they ended up showing up. So they were late. My memory is kind of like Tom's. The stories you've heard, capias would have been issued. I do think, I'll say this, I think one time we had someone who called the morning of and was in the hospital. So obviously we just had to reschedule that one. But yeah, I mean, I have not been on a panel where we've had to issue a capias for someone not showing up for that hearing.
Yeah,
and it's very possible that could happen.
And you've got to think. I mean, there are a lot of reasons why lawyers would become involved in a situation like this to begin with. Most of the time, my impression is that it might be the result of a couple of issues that we'll see. And in fact, when I was talking with Vanessa, I think she confirmed this too. Sometimes it's just maybe a younger lawyer who first gets the notice from the clerk and just freaks out. Like, oh my God, I haven't filed my brief on time. They're going to come after me. And then it just spirals down from there. And if the lawyer simply is offered the off ramp, the other lawyer will take it and there you go. Sometimes it's the result of maybe substance issues, mental health issues, otherwise that are more properly referred to the Tennessee Lawyers Assistance Program, to TLAB. At least out here in the East, I haven't seen it much where the lawyer is just obstinate, where the lawyer is just, I do not care what you all say. I'm not going to abide by your rules any longer. I haven't seen that out in the East much. Yeah, so by the time if we get to the point where the lawyer is not showing up for the contempt hearing, if the lawyer is ultimately found in contempt, that fact is going to be a very bad fact when it comes to assessing the consequence of what's going on. So, the best advice is that if you, it's like everything else in life, frankly, if you admit your fault, sincerely try to mend your ways, I think the lawyer's going to find that the court is not interested in holding anyone in contempt. The only thing we want to do is just proceed with the appeal. So, you come into the contempt hearing saying, look, I really messed this up. I'm so sorry. I've already taken care of it. I filed my brief before I even got into the courthouse. I'm ready to go, but also, accept whatever consequence comes from that. I think the lawyer's going to find that in the vast majority of cases, the court will say, fine, just don't do it again. Pay attention to our orders. And then everyone will go on about their business. It's when I think sometimes without cause, the lawyer tries to vigorously defend an action without real cause. I think that's when when the train comes off the track sometimes.
Well, that leads into another question that I had. So what are some of the potential outcomes of a show cause hearing?
So, yeah, I mean, Tom alluded to the best outcome, and the best outcome is the lawyer who shows up with a file-stamped copy of the brief that they were in the clerk's office before the hearing ever started, getting that brief filed, and they can tell us, fall on my sword, I screwed up, whatever their excuse was. I moved offices, whatever. But hey, I just filed a brief. Everything you've asked me to do has been caught up before this hearing ever started. The outcome there usually is a dismissal of everything, and you just move on. And it can go from that all the way to Tom and I were on a panel in which it was clear. This is how I'll describe it. Tom, you may describe it a little different, but it was clear that this gentleman just did not have control of the administrative processes in his office. He was never really in the office. He had like a part-time administrative assistant who may be checking the mail. He got some stuff on his phone, anyway. Long and short of it was clear he didn't know how to run his law practice, and at least the appellate part of his law practice. And so we put him on a monitoring program, had him find a mentor who he would file a quarterly report with us saying, I've got, because he had a handful of appeals at the time. That was part of the other problem was, and so it went from someone who walks in with a brief to us finding a mentor, so to speak, for someone. They file quarterly reports and updates where all of his appellate cases are, what he's resolved, this, that, and the other. And in those cases, when you get to those extreme cases, usually what we do is we say, here's the 1, 2, 3 things, whatever it is that we're requiring you to do. We're going to find you in contempt, but we're going to hold that contempt finding in abeyance and the punishment in abeyance. We're going to give you a list of 3 to 5 things that we need you to do. And if you do all those within the time period in which we ask you to do those, we will dismiss the contempt charge. That would be at that kind of extreme. I guess the only thing I can think of is just outright finding them in contempt, removing them from the case and reporting them to the BPR would really kind of be worst case scenario. Tom, what?
Yeah, I think you've laid out all the options very well. I think we have, at the one end, Nick, you've got lawyer comes in and has already remedied what we were concerned with, and so the court would simply just dismiss the proceeding. There is, in my experience in the practice of law, having had the privilege of practicing before a number of judges across the nation, some outstanding judges, others just very good judges, I've not encountered a single person who ever said, hey, I want to be a judge because I want to hold people in contempt for not filing briefs. I've not seen that judge yet. And so I think most of the time, if you come in and say, I've already taken care of this, I'm going to accept whatever consequence you have, I really think the judges on the Court of Criminal Appeals in particular are going to say, just don't do this again. Pay attention when we send you all these notices. Other things can happen too, though. And the legislature has provided that the possible punishments for contempt can include a fine, can include up to 10 days incarceration. I've not heard of anyone being incarcerated in kind of more the modern times as it goes. But you could have the possibility of a fine. The sanction that I would be most worried about, frankly, is reporting to the BPR. So once that contempt finding comes down, if it's not, for lack of a better word, expunged after the probationary period, once that comes down, there will be a report to the BPR, and then the Board of Professional Responsibility may initiate then a disciplinary action. And that disciplinary action is going to follow that lawyer then for the rest of the lawyer's career. I mean, the contempt will too, but if it's expunged, that's probably explainable later on. But if there's a disciplinary action that results in discipline, that's going to follow the lawyer. And that's really what, as a lawyer, that's what I would want to avoid most importantly, is that referral over to BPR. I think it's fair to say, at least in the case that Ross alluded to that he and I were on, the lawyer in that case, I think had gotten in some trouble, as Ross says, because of maybe some office management practices. Not a bad lawyer at all, but that will happen sometimes in the practice of law if we're not watching out for it. He filed, we had asked him to file quarterly reports and be subject to a practice monitor. He did that. The reports were good reports. Every time we got one, he explained, hey, these are the cases I have up in the Court of Appeals. This is what I have pending in the trial courts. This is what we're doing to stay on top of it. And I think we required it. My recollection is maybe a year's worth of reports. But after we got the last one, it seemed clear to me that the issues that we had encountered had been resolved, and we dismissed the contempt proceeding. There was no reason to go any further than that. The issue that we had identified had been completely remedied, and all for the better of everyone involved. So there are a lot of different ways you can go about it. Once again, if I can emphasize anything on this podcast, is that just recognize the fault if there is, and acknowledge it and fix it, and try your best not to do it again. Like I said, there's no one on this court, I think, that wants to hold people in contempt. That's not why we go to work in the morning.
No, and if I can piggyback your guidance there, Tom, one of the things, Nick, I say, I think any of my colleagues who are doing them or a part of them at times, we tell attorneys at the end of all these hearings, look, we don't want to be here. We know you don't want to be here. And the best way for us to never see you in this fashion again is, there's plenty of people you can call. Lawyers that you're friends with, you can call and say, hey, I've got this appeal. I don't really know what I'm doing. If that's the case, there's people at the clerk's office who will answer hey, you just need to do this. Call the staff attorney. The staff attorneys are great about, okay, yeah, I get it. You missed this by 2 days. Here's how you need to remedy that. I can promise you they all want to keep you from having to appear in front of one of these hearings. I remember as my time in the AG's office, we crawled under the chairs when these hearings took place just because it just is uncomfortable. Here's one of your colleagues getting reprimanded by the court or who does the same job, so to speak, that you're doing. And it's just not comfortable. No one wants to see any lawyer standing up in front of 3 of us having to go through this process. So to your point, Tom, if there's anything I can stress, it's do everything you can, phone calls, respond to emails, whatever, talk to your buddy so that you don't have to see us.
Judge Dyer, Judge Greenholtz, thank you so much for joining me today on Tennessee Court Talk and helping to explain not only a show cause hearing, but much more in-depth perspective of a sometimes unknown procedure in our court system.
Well, Nick, thank you very much. It's been a pleasure. Judge Dyer, great to see you again.
Good to see you, and thank you, Nick. Appreciate it.